Heyo and welcome to Young Thug RICO trial. Yeah, we are going to pick up from where we left off with Judge Slate, prosecution nagging, and Mr. Steele trying to get completely reasonable motions in. Well, that and more on today's show. Welcome. Yeah, we are going right into the recap of there you go. The recap of Friday, which I'm going to play in 1.25. And when that is done, we will see what has been going on Monday. So let's get right into it.
Mr. Stillwell and Mr. Sharp, good afternoon. All right, Mr. Williams, Mr. Steele, Mr. Adams, and Mr. Renard, good afternoon. All right, Mr. Kendrick and Mr. Weinstein, good afternoon. By the way, I like the purple. Very nice. Very nice, very nice. All right, Mr. Huey and Mr. Matthews, Junior and Senior, good afternoon today.
She goes to Spelman University, and she applies to law school. She got accepted into N.Starow, University of Chicago. We have news.
Okay, there you go. The law student.
I told you, as I mentioned earlier, obviously low performing, but you'll manage, okay? All right, okay. Welcome, madam. You are welcome. All right.
Yeah, this is very nice. Getting a law student to sit in on this trial. I assume it is to tell her, look at this judge, look at this prosecutor. Those are bad people.
Mr. Smith, Ms. Hilton, Mr. Atkins, and Ms. Love, good afternoon. All right, okay. Still waiting on some jurors, as I understand it, but as was indicated yesterday, I believe that we needed if memory serves me correctly, Mr. Steele and Ms. Hilton, I need a rule on State's Exhibit 175, Charlie Echo, specifically the portion 415 to 455. Is that correct?
Yes.
All right. Is that correct?
May I speak?
Yes.
You said 415. It's actually 406 to 455.
All right. Okay. And can I listen to it?
Yes, Your Honor.
All right. If you'll play it, please.
Okay, this is the portion from a jail house call where the defense want an item thrown out to be redacted because in that recording, Mr. Bean's wife is mentioning Young Thug's name. And I assume you who are here, and I assume I am, of the notion that double hearsay really don't know. No, just no. So, and I'm not going to bother you with that recording.
Gave us a continuing objection.
I have.
That being said, 406 to 455 is what I'm targeting.
Okay, I'll hear argument on that at this point in time.
Do you have the copy of the transcript, post-transcript?
No, I
I'll
don't.
give you a copy.
That'd be helpful.
Oh, wait, I may have one. Hold on.
No, I don't think you do.
No, it probably
Shut
not
up,
the same one.
prosecutor.
All right. Okay, I'll mark this as the next court exhibit in order. It references, it purports to be a jail call of Exhibit 175, Charlie Echo. Counsels, I assume that this is this the entirety of that particular call?
No,
Or is this a section just talking about 406 to about 455?
Your Honor, this is the section that the state intends to play. So it's actually two portions. 1 minute to about 57 seconds, and then from 4:06 to 7:15 where I ended it.
I need to get a new shell. This one is
Okay,
creaking like
The
crazy.
relevant portions, Your Honor, will be on beginning on page.
Yeah, earlier in the trial, the prosecution was very adamant in transcripts are not evidence unless they need it. Now they want the recording played with the transcripts. Yeah. Fun times.
The bottom of page 3, where it says
3 of 8.
3 of 8, right after it says break, and
Okay.
Agent Bean says, you said you saw what they
Okay.
said.
All right, okay. Now that I've oriented as to the transcript. All right, Mr. Steele, since your objection, sir. What's the basis?
It is hearsay, Your Honor, and it is double hearsay. It is on page, the relevant portion really starts, I know it does start on page 3 of the next court exhibit. I don't know what number that is. But going on to page 4.
I'm sorry, one more time.
4 of 8.
4 of 8?
Yes.
We'll be right, everybody.
And in the big paragraph, it says Courtney Bean,
Yes, sir.
starting on line 7.
Okay.
And Courtney Bean is repeating what other people are saying, and she's not going to be a witness from what we were told. It says, right, that's what, but people pull you on like they don't, but hold on, first off, all of this, what the trip, because nobody even know you was with them. Everybody keeps saying buck, buck. They thought it was buck, buck, thug, all the other. I would argue that all of that is other people, supposed statements coming through Courtney Bean to Adrian Bean over the recorded call. I asked you to exclude all that. It then continues.
What's the what? Where, sir?
Okay, I apologize. I started on page 4 of 8,
Yes.
line 7. Courtney Bean, according to the transcript, which I did look at the transcript, there are some slight changes, but it's for purposes of our conversation, it's correct. And it says, right, but people telling.
People telling.
I think the word is what, but I can't be sure.
I'm going to give an admonition that talks about that too, if I decide that it's admissible to begin with.
Understood. It says, but people pull you on like they didn't, but hold on first off all this, what the trip, because nobody even know you was with them. Everybody keeps saying buck, buck. They thought it was buck, buck, thug, and all that. And I don't hear the word other, but it's in there. So my point, I stopped there. It's on line 11 on page 4 from 7 to 11. All of that is Miss Courtney Bean, who's not a witness. That's hearsay. And it's Courtney Bean repeating what other people supposedly say or think or tell. So all of that, Your Honor, is for the truth of the matter asserted. And I make the same objection I made on C 175 CC. Then it continues. Oh, I'm sorry.
Go ahead.
And then it said they, buck them running around. You know what I'm saying? Thug them running around, telling them people it was Bean. Is again, it's other people being supposedly told. You don't know if where Miss Courtney Bean's getting from. Miss Courtney Bean is not a witness, so I object under hearsay. Then it says, you know what I'm saying? That you was with them, you, and I think it says C, but it says feel what I'm saying. People did not even know you was with them, Shawty. Again, it's other people's thoughts. So she had to get that from hearsay, other person's thinking or speech. And said they didn't even know you was with them, meaning other people. That information had to come from a third party who's unknown. They did not know at all. Same answer. They kept talking about buck, that's somebody else speaking, not Courtney Bean. It'd be hearsay, double hearsay. Everybody thinking it was buck. That's speculation, what other people are thinking. And hearsay. Goes on to page 5 of 8, Your Honor, at the very top, line 2. Then I guess Dirty Red supposed to go, however it's supposed to go. That is speculation. It's also talking about what Dirty Red knowledge is. He's a gentleman, Derek Dotson, God forbid, he's deceased, he will not be talking. Then it says talking about Ken going to put a hit out on you all. So that's another person, that's a third party. That's hearsay. That was his money. All type of OSHI blank. That's what Cheryl, who is, I don't know who that is, and Cheryl spelled S in this, it's spelled SHERELLE, told me last night. I don't have talking about, I think that's not there. Then it just says Big Homie's baby mama. So I assume that Cheryl is whoever Big Homie's baby mama is. I said, honey, please. So my point to you is, it appears to me in this section, Your Honor, that you heard, but I use the transcript just for ease. And I do understand that the recording is the evidence, but just for ease, for the purpose of this motion, everything here appears to me to be hearsay from either Courtney Bean, who's not a witness, or Courtney Bean heard it from someone else. So that would be double hearsay. And that person, to my knowledge, is not testifying about any of this either. So
So
my objection is the same.
So I understand if I understand your objection correctly. You are specifically asking the court to exclude from page 4, lines 4 through, page 4, lines 7 through about 18 in total. And
Page 4.
lines 7 through 11. Is that correct?
No.
7 through 18, I should say.
Yes, but then going on to page 5, line 2 through
Yeah, I know.
6. Yes, that's exactly right. It's basically that entirety of that hearsay. That's what I'm talking about.
Okay.
And then that was it for that portion.
Is there anything else on this tape that, other than that section that from 406 to 455, are those two sections, are those the ones you're talking about?
Yes, without waiving the other issue raised by Attorney Sharp. Yes, that's
Okay.
exactly right.
All right. So
Thank you, Your Honor.
And now she's gonna nag his ears off trying to get double hearsay in.
Your Honor, the state does not intend to introduce the section on page 4 through 8, which starts at lines 7 through 20, or page 5 through 8, that starts at lines 1 through 6, as hearsay. Sure. The state does not intend to introduce those portions as reference as hearsay, Your Honor. We are not offering it for the truth of the matter asserted within what she has said.
That's some absolute bullcrap. Absolute bullcrap. Absolute bullcrap. Hey, dear Robertson. Says, I really do like the bonnet. I do too. I do too. Now, again, it is hearsay. I don't care if it's not, if they try to assert it as not for the truth of the matter. It's hearsay, and it should be thrown the fuck out.
The truth of the matter would be, we want to believe that everyone kept saying it was Buck Buck. That is not why we are offering it. The reason why the state played the entirety of 406 all the way through 713 was to show that this particular conversation has an effect on how Adrian Bean responds to Courtney Bean, given what she has said to him. So
Doesn't matter, still hearsay. If anything, this entire conversation should be thrown out.
immediately following what Courtney Bean references, he goes into what he did and what happened back on September 11, 2013. So whether or not Buck told the people in the community, whether or not Thug told people in the community, we're not offering it for the truth of the matter asserted. We are offering it to show the effect on Adrian Bean, which immediately after Courtney tells him this information.
And Mr. Bean is not on the stand anymore, so it doesn't matter. It really doesn't matter. Shouldn't be allowed in. If slimmer of hope of getting it in normal cases, it would have been during Mr. Bean's testimony, not crooked cop Mr. Quinn.
He goes into page 5 of 8, line 8. Nah, that ain't got nothing to do with us. Niggas got me fucked up. I ain't got nothing to do with none of that shit. I don't know what the hell was going on. I was taking a nigga to get some lean. Nigga said he called Ken about the lean. He go down there to see the lean, and that was about it. So I don't know what the hell a nigga talking about. So again, all we're offering it is his effect on his response to what Courtney is saying. And then Adrian Bean proceeds to go on about everything else, rehashing what happened on September 11, 2013. And Your Honor, the state has 2 cases in particular that discusses non-hearsay. And I do have a copy from Mr. Steele in the court. The first case, may I approach, Your Honor?
No.
You can.
I've been saying this for a while now, that the exceptions of the hearsay rule should be rolled back at least 20 years. A complete all over restart, because it's getting stupid. Correction, it is stupid. The amount of exceptions to hearsay rule that is only there to make it easier to prosecute. It's not supposed to be easy to prosecute. It should be hard. You should be presenting solid evidence, not fucking gossip.
Yes, paper clips together. Honor is Brown v. State, which is 332, Georgia App 635.
Hey, so
And you can find it in Division 1. And it states, when we have the holding from the court, OCGA 24-8-801 provides hearsay means a statement other than one made by the declarant while testifying at the trial or hearing, offered in evidence to prove the truth of the matter asserted. Whether an out-of-court statement is hearsay depends on whether it is offered for its truth or merely for the fact that it was made, where the alleged fact is only so if the substance of the statement.
hold on here. Let's see what the first.
When we have the holding from the court, OCGA 24-8-801 provides hearsay means a statement other than one made by the declarant while testifying at the trial or hearing, offered in evidence to prove the truth of the matter asserted. Whether an out-of-court statement is hearsay depends on whether it is offered for its truth or merely for the fact that it was made, where the alleged fact is only so if the substance of the statement is the truth, the statement constitutes hearsay. On the other hand, where the alleged fact may be so regardless of whether the statement is true or false, the statement is not hearsay. We don't care if that statement about Buck or Thug is true or false. We solely are bringing it in to show what Adrian's response was to Courtney.
Here's the thing. Adrian Bean is not on trial. Mr. Williams is. Adrian Bean is not even charged in this RICO trial. So if anything, that would be an exception if Adrian Bean was the person charged with in this RICO, and he isn't.
Telling him this information. So whether or not Big Ken was going to have a hit out on them, again, true or false, it does not matter. We are bringing it in solely for what Adrian's response to that was, which was, nah, I ain't got nothing to do with that. That ain't got nothing to do with us. So again, that was his response. It was his effect, the effect on the listener, Adrian being the listener, for which the reason why the state is bringing in these statements. Again, continuing in that Brown case, Your Honor, it says, in this particular reason, the statements are not hearsay because the state offered them for a purpose that did not require the jury to assume that the substance of the statement was true. Here, the evidentiary facts that the state offered the statement in that particular case was to prove that there was a conversation about a payment of drugs, money, and that the mother was going to pay for some drugs. But again, the state is not offering this particular statement about any truth of what Ms. Courtney Bean was saying at all. It is solely to show Mr. Bean's response to what his wife was telling him. And Your Honor, the way that this portion of the conversation starts, she asked him, if we go back to page 3, right before this is the part that the state does not intend to play, but they're talking about what's on the news as it relates to this particular incident. And so we start this particular portion at, you said you saw what they say. Adrian's asking Courtney Bean that. And her response was, who, the news? And he says, yeah. And then she continues to say, oh, the news don't say nothing. Oh, the news don't say nothing but a suspected shootout with police. That's all. That's all. They ain't say nothing about no robbery. You tripping. And then Adrian says, man, they talking about a shootout with the police. Courtney said, it don't say nothing about no robbery. That's all the news say. And Adrian says, everybody think I had a shootout with the police. And then she goes in to say, well, let me tell you, this is what these folks are saying out here in these streets. Right or wrong, his response is,
Happy Monday, everybody.
That ain't got nothing to do with us. Niggas got me fucked up. So again, it's not about what she actually said. Adrian is responding to Courtney, given this entire conversation. Then again, he goes on to explain.
This is not a trial against Mr. Bean. So off you fuck.
Explain everything. So for that reason, Your Honor, the state would ask that you deny Mr. Williams' motion. The other state is Graham v. State. It goes for that same proposition, Your Honor, that again, because we're not offering it for a hearsay purpose, this is non-hearsay, that we are asking for this portion not to be redacted.
All right.
Graham is, and I apologize, 331, Georgia Act 36. And the relevant section is in Division 2 of that opinion. You're welcome.
All right. All right, Mr. Steele, anything else for a rule?
Yes. The only time in this recording that thug, the word thug, the name thug is mentioned in Exhibit 175 CE is in the section that we have. And it is not needed to explain anything on the listener, because if it was, Adrian Bean was a witness here. He was never asked about this recording. He can no longer be cross-examined about this recording. To say it had an effect on him is pure hearsay. That's why I'm moving for the whole tape to be recording to be excluded. I understand your ruling, so I'm not going backwards. But that is being offered for the truth, because then the state is going to say thug was mentioned by Courtney Bean. And then the state is going to argue that if it's not for the truth of the matter asserted, then they should not come in. If the court wants it to come in, then it has to be respectfully redacted from thug under 403. Because if it's not for the truth of the matter, why does it matter that thug was mentioned?
Well, it's a conversation that she's having, but it's not hearsay. It's the effect on the listener.
Well,
And then the 403 analysis.
That's
I'll hear
some
that. So,
absolute bullshit.
Under 403, why is it more prejudicial than probative?
Well, first of all, I disagree. It's non-hearsay because the state is using it for the truth of the matter asserted, because otherwise it's irrelevant. You don't need
That's
this
their
to
argument.
explain.
And that's yours.
Okay.
Okay.
I
All right.
thought you were fine. Okay, I'm sorry.
That's okay.
To put thug in there on a witness I can't speak with who says that she got this from a third party named Cheryl, I think, yes, I have major problems with that.
As
And
anyone
saying
should.
That's what people are telling
As anyone should.
on line 7 of
Effect
4
on
of
Mr.
8
Bean
starts
is
out right.
complete bullshit.
But people, I don't believe the but said, but whatever, that's what it says. That's what, but people telling, but people pull you on like they didn't, but hold off on first of all, this is what the trip, because nobody even know you with them. Everybody keeps saying buck. This is all repeating unknown third parties or fourth parties or fifth parties. I have no idea who these people are. They said they thought it was buck, thug, and all the other.
But remember, it goes to show Bean's. It's contextual because right after that,
No.
Bean
No,
says,
Judge.
"No, I ain't got nothing to do with this." I mean,
No. Mr. Bean is not on the stand anymore. It's irrelevant to this case. Completely irrelevant. But here we are.
he's responding to a statement that his wife made at that point in time.
Not exactly sure I agree with that. If you go up above that part that I'm challenging, on line 1 of page 4 of 8, Adrian Bean, man, they talking about shootout with the police, Courtney Bean. It don't say nothing about no robbery. That is all the news say. Adrian Bean, everybody thinks I had a shootout with the police. Then if you go to where I'm not challenging, on page 5 of 8, Adrian Bean says, nah, I ain't got nothing to do with us. N's got me effed up. I ain't got nothing to do with none of that. He never says anything that he has to respond to. That is all just an argument to get this in. And if it's not for the truth of the matter asserted, then clearly it prejudices Jeffrey Williams under 24-4-403, because I can't cross-examine anybody who's made this statement. Either it's Courtney Bean or whoever she supposedly heard this from, or if she made it up, or if she was joking, or there's nothing here. So the jurors are just going to hear how thug is involved. And that's, I think, extremely prejudicial, especially if not offered for the truth. Because Mr. Bean, you would notice, he never says anything about thug. He never says anything in this conversation about Jeffrey Williams. So the only time it's used is when the state is saying, well, we don't want it for the truth. We just want a response to just, if the state really feels like that and you really agree with that it's an effect on a listener, then I respectfully fall back on a 403 argument, because I can't do anything with the word thug, and it's in 2 places.
All right.
But I'm really at my first argument.
Okay.
Right. As it relates to the 403 analysis, Your Honor, it is not.
Usually, if this judge had an inkling in court decorum, Mr. Steele has the motion, he argues. Prosecution whines and bitches about it, and then Mr. Steele gets the final word. That is how it's supposed to be. Not in this courtroom, because Judge Glanville has no spine. he lets the prosecution nag and nag and nag. And yeah,
substantially more prejudicial, Your Honor. If you even read the portion that Mr. Steele is asking to be redacted, if we believe it,
yeah, I'm
well,
going to skip.
and then Mr. Steele,
I don't want to hear.
All right, folks.
Hey, Paralegal Liz. Good to have you here. Come on, Judge.
Okay, based on the court's hearing of States 175 Charlie Echo, relevant portions 406 to 455, I'm going to overrule the objection at this point in time made by Defendant Williams. The court's had an opportunity to take a look, not only listen to the evidence, also take a look at the transcript, which will also be included for the purposes of the record as the next court exhibit in order. The court transcript admonition. All right. Anything else, sir?
Yes, there's one on C, on 175C. I believe that part of this was on the court, but it's still in the transcript.
Hey, Tammy.
this is after the chicken portion. This is
Remember to hit the thumbs up. And if you haven't subscribed yet, please do. I would really, really appreciate it.
John, can we just have a second?
Yes.
Skip ahead.
Tuesday or Wednesday when we were here,
And here's Detective Quinn, the true crime TV show host, best friend with crooked cop, former Detective Velasquez. Who Detective Velasquez, if you don't remember, is the person who on the stand, under oath, admitted to destroying evidence if he thought it didn't suit his case.
talk briefly about you speaking with or attempting to speak with Frederick Prothero and Walter Murphy. I want to go back to that briefly.
Yes, ma'am.
Where did you go to try and speak with them?
Grady Memorial Hospital.
And I think earlier you said you were unable to speak with them first. Why were you unable to speak with Walter Murphy?
Well, I got to Walter Murphy's room. Yes, his family members in there. They immediately told me, I'm sorry.
Hold on. Who said that? Is that you, Mr. Matthews? All right. Mr. Steele, I'm going to sustain both objections.
Yeah, don't tell us what they said, just what happened when you went to the room.
I found out when I got there, he'd been under medication, in particular morphine. And I didn't want to speak with him if he was under the influence of any kind of drugs. So I discontinued the interview. I did audio tape that exchange at the hospital, but I didn't take an interview with him because of the drugs.
And what about Frederick Prothero?
When I got to Frederick Prothero's room, he didn't want to talk.
You got to stand. I got the old and you are. So I'm
You're
going
right.
to sustain the objection.
He didn't say what he said. He didn't say any. He didn't say anything. He just said he didn't want to talk. I mean, that's not here.
I will reverse myself. I'm also overrule the objection. Okay. All right. Go ahead.
All right. Now, when we left off on Tuesday, we were actually talking about jail calls. Why is it important to listen to jail calls?
Jail calls, they're good evidence for me and what I do.
I'll sustain as to form. You can rephrase, Ms. Hilton.
In your experience, have jail calls been helpful in your investigations?
I would say so, yes.
Why have they been helpful in your investigations?
Overruled. Mr. Matthews.
It's just a tool in my toolkit. You know, I have different tools that I use when I work these cases. That just happens to be one of them. It's evidence.
Unless you decide it's not. Do you do that, Mr. Quinn, as your best friend, former Detective Velasquez does? Erase things if you don't like it?
And I think we talked about earlier on Tuesday that you were able to pull jail calls of Adrian B.
That's correct.
And when you listen to those jail calls of Adrian B, do they assist you in your investigation?
Absolutely.
And briefly tell us how did it assist in your investigation?
For me, it was an inflection point in my investigation because I had no information other than the rudimentary evidence that was collected at the scene and the testimony from some of the law enforcement officers.
And as you listen to,
So you knew who was there, but it wasn't enough. You wanted the jail calls. Why?
some of those calls, did you find calls that gave you some additional information?
Yes, ma'am.
Who was he primarily speaking to on those jail calls?
Courtney Bain, his wife.
And at some point later, did you have the opportunity to play some of these jail calls for Adrian B?
Absolutely, I did.
And when you played those calls for Adrian B, did he acknowledge his voice on those calls?
He did.
And did he also acknowledge him speaking to his wife in those calls?
Yes, ma'am, he did.
In preparation for your testimony today, have you had the opportunity to listen to some of those calls in preparation for today?
Yes, ma'am.
And did those calls appear to be a fair and accurate depiction of the calls that you listened to back in September of 2013?
They did.
Of the calls you listened to, did they appear to have any additions or deletions?
No.
You mind permission to approach?
Have you shown those to defense counsel already?
Defense counsel has the
Okay.
calls we're going to hear today.
All right.
I'm going to show you what's been marked as State's Exhibit 175. Tell me if you.
And that's the recording. Let's see here.
Play 175 Charlie Alpha and the subsequent recordings that the court just admitted. You'll be given a tape and then a corresponding transcript. And I'm going to read.
I don't like when the court supplies a transcript. If the jury is the finder of fact, then they should do so without the transcript, in my opinion.
You an admonition that I want you that will follow each of those particular recordings to give you some direction, okay? Ladies and gentlemen, we are going to play a tape at this point in time. It is for you to make the factual determination of whose voices are on the tape. You will determine what that is. Also, you will be provided with a transcript of the tape. Let me explain that to you. It is what somebody else thinks they heard on the tape. The judgment of what is said on the tape is your judgment, and it's the tape.
Yeah, last time we had a stream, he said it had to be redacted. This, I believe, is another tape where apparently the judge reverses himself and says, yeah, it's perfectly fine to play this part of a tape where when the witness is no longer on the stand and can't be cross-examined, talks to his wife, who is not called as a witness, who is referring to unknown people saying something about Thug. And the judge allowed it because apparently hearsay rule don't mean shit in this courtroom as long as they can pin something on a defendant. Make it easy for the prosecution. Why bother with good evidence when you can have the judge agree to submit horrifyingly bad evidence that should have been thrown out ages ago? And remember, when this happened back in 2013, Mr. Williams was never charged. Isn't that weird?
That is the evidence. As to the content of the tape, if there is a discrepancy between the tape and the transcript.
The audio call was difficult to understand technically. Yeah, I agree. And still, transcript, that is another person's opinion that can be construed as a fact. Hey, from Denmark. Hello, Maja.
you are to ignore the corresponding transcripted portion of the recording, and that any discrepancies between the tape recording and the transcript are to be resolved in favor of the audio tape. Further, ladies and gentlemen, it is not permissible to take notes from the transcript, only from the tape if you should desire. And after each recording's been played in the transcription, we will take up that particular transcription, and then we'll provide you with the next transcript for your consideration. And the same admonitions will apply, okay? All right, thank you, ladies and gentlemen. All right, Lieutenant Walker, if you will hand out those, ladies and gentlemen, just take one, and once all of you have a copy, just.
Yeah. Speeding through.
What you want me to do by fill out with a free call? I'm downstairs. Okay, wow.
Yes.
They're going to get it right there.
Now going to 8 minutes and 24 seconds.
Yes.
Prior to this call, did you know who Ken was?
Yes.
Okay, how?
Interview I conducted at the homicide office.
Okay. And also they talked about within that portion, did you hear Adrian Bean talking about following behind the Taurus
I did.
and going through the gate
Yes.
and police getting out and shooting at the car?
So not only did they get a transcript, now this cop is telling the jury what they heard on the tape.
Correct. I heard that.
Had all that information come up in your investigation prior to you hearing those jail calls?
Yes, ma'am.
And at this time, had you yourself spoken at all with Adrian Bean?
Not at all.
And we're now going to listen to 950 to.
So they are trying to tell us all that on the Brady Hospital, Detective Quinn talked to two of the suspects, but ignored the third one. Yeah, I don't buy it.
Point 1006. We'll start at 9:45.
After we fair, I'm glad one nigga just hit me in the head, shoot me, walk us me. That nigga thought they got down big friends.
Yes.
And that vehicle being the red Nissan Altima.
Correct.
Come on.
Now playing at approximately 11:15 to 11:45.
Hey! Hey, folks from Legal Vices! Yay! I'm going to send Jeff an invite. Let's see if he can be forced to stay awake. Dun, dun, dun. There he is. Dun, dun, dun. He has 20 minutes. Good. I sent you a link. Oh, you're going to like this. Oh. Oh. Yeah. Welcome, people from Legal Vices. Lorax Raid. Hey, Jeff.
Hey, what's up? Is this guy praying?
I'm so frustrated. No, they're listening to a jailhouse call, which is jive in code.
I don't want to hear about frustrated. I just got done with another Hales hearing. I don't want to hear about your frustration.
Yeah. Oh, by the way, what we are listening to here is a jailhouse call, which portions wasn't redacted due to not asserted for the truth of the matter. Yeah, where Mr. Bean, who is not on the stand,
yes.
He was excused permanently last week.
This is a jail call with Mr. Bean.
Yeah.
And everybody that just followed over from my stream, Mr. Bean is the guy who was saying, it was like, can I have a drink of water? I'm so hot. Yeah, that was Mr. Bean. And it's not one of our law tube nicknames. That's like literally his name is.
Yeah, his name is Adrian Bean.
Yeah, his name is literally Mr. Bean. It's not just us being cute and funny and giving people nicknames.
Yeah. Well, now he was excused last week permanently, so they can't recall him. This is Detective Quinn. Detective Quinn has a true
a bad
crime
haircut.
show.
Oh.
He has a true crime show with Detective Velasquez. Detective Velasquez is the cop who, about a month ago, on the stand, admitted that if he didn't like the statement witnesses gave him, he deleted it
Oh.
until he got what he believed was the truth,
Oh.
also known as destroying evidence.
Yeah. That works.
And since he deleted it, we don't know what was said between him and the witness until the witness gave the statement he wanted.
Well, how convenient is that?
So these two are best friends. Now, the portion that the defense wanted out was the portion where Mr. Bean, on a jailhouse call, is talking to his wife. Okay, Mr. Bean, permanently excused, can't be called back. His wife will not be called as a witness. His wife is referring to something she heard from someone about Thug being involved. But since it's not...
Sounds a bit like hearsay to me.
Yeah, sounds like a bit of hearsay. But since it's not truth of the matter asserted...
Oh, okay, yes.
Yeah.
Of course it's
So,
not. Of course it's
Of course it's not. So it's such bullshit.
See, people, I told you that every day there's something going on in this trial. And Nick only has like 2 more years of this to look forward to. Well, maybe less, because now that his wife's not being called, there's only 709 prosecution witnesses.
Yeah. Somewhere along during the week break or earlier, they cut it down by a judge's order from 771 to only 400.
Okay. Sorry.
Yeah. This trial started end of November. We are now end of March. They have so far called 40 witnesses out of 400.
10 times more to go.
Yeah.
So, another 470 days.
Yeah.
Well, that's just for the prosecution's witnesses. Though. The defense still gets to call 870 billion witnesses.
The defense, I think, have limited themselves to around 90.
Okay. Yeah.
But Mr. The attorney for Mr. Richards, I think. Is that his name?
The angry guy?
Yeah.
Like gets up and yells at the judge all the time.
That's Mr. Steele.
Okay.
He is a good lawyer who apparently about 6 or 7 years ago filed a motion against this very judge, and in appellate court got the thing overturned. So the judge may or may not have some retaliation.
I like that guy. He's like the stereotypical angry New York lawyer. He's like, hey, I'm after you, Judge. I'm just doing my thing here. Why do you hate me, Judge? You don't listen to me, Judge.
Yeah. Oh, by the way, we are down to only 3 alternates.
This is going to be a mistrial long.
Yeah. So there are 12 jurors, 6 alternates, 3 alternates already gone.
This is not going to a judgment. There's
No.
not going to be a verdict in this case.
No.
And I have no fashion sense whatsoever in my life. I'm completely a fashion void human being. I just know that you're not supposed to wear brown and blue together because my mother told me you're not supposed to do that. I don't know why, but she said you look like a bruise. But
Gray on
I
gray
know you
on gray
don't
on
wear.
gray.
Yeah, you don't wear gray pinstripes with a gray pocket square and a gray shirt and a gray tie with your gray glasses and your fucking stupid gray goatee and gray fuzzy head thing. Your Velcro head. There's a little too much gray. The point of a pocket square is to contrast with your suit color. I know that much.
Yeah.
And if I'm critiquing your fashion, you got some serious freaking problem.
All right, but now
I'm wearing
when
a
you are,
Dungeons and Dragons shirt and a Polish fisherman cap, for God's sake. And I'm telling you, he's got bad fashion sense.
all right, but let's listen a bit more on this jail call. I was going to skip over it because we heard a few already, and yeah, I got bored. Let's see.
Hey, what's this guy's name?
Detective?
We're gonna start at 11:06.
Detective something or other.
probably relief or a waiver for her. She can go down there and get a little
Wait,
$300.
time out, Nick.
You know what I
I'm
mean?
sorry to interrupt you one more time. Is this guy wearing a 1980s square and knit tie?
Yep.
This is a knit tie, and if that thing has a square bottom on it, straight out of the 1980s, oh my lord!
I think I have one of these somewhere, but
I don't. I haven't since the 1980s.
I'm not allowed to wear it anymore because I work with females and I have sisters and I have my significant other who will strangle me with it if I even thought about it.
That is a knit tie. Oh my god! You got that like from a museum somewhere. I'm sorry to interrupt. That just kind of caught my attention.
No. I'm
It was
fine.
weird.
Oh.
And they're gonna be that. I don't think I just gotta do it. Goddamn, just try to make sure them lame don't even come to court with dad. Goddamn, because they talking about the old man, that old boy.
So, yeah,
Are you
so,
going to
let me take
translate
care
this
of
from
that.
Swedish
Let me
into
talk
English
to
for us, Nick?
Sure. Oh, dear sir, on the other end of this recording, what did you have for lunch? I have no idea what's going on. But the jurist does have the transcript provided by the state.
I don't think the transcript's going to help.
But they were instructed by the judge that if there is a discrepancy between the transcript and the audio, they should rely on the audio.
Yeah, I think he's got like a watch. He's got some sort of bracelet. Looks like another friendship bracelet and perhaps a fitness tracker on his other wrist. It doesn't look like he's got two watches. Then I'd really have to punch him in the neck.
Oh.
Anyways,
We calm. I mean, cool with. Yeah, we'll try to keep the days out of that. I can't get no more probation, man. I ain't got no probation, no record, no none of that shit, man.
Does anyone here speak jive?
Yeah, we're trying to get your ass out, man.
I asked last week for a jive translator, and no luck.
Oh well.
But the prosecutor then asks Detective Quinn here, or retired Detective Quinn here, did you hear this? Oh, yes, I heard it. Did you hear this? So not only do they have the transcript, which may or may not be correct, then just to make sure, they ask Detective Quinn what is actually said in it, just to make sure the jury gets the state's version.
Salvador Dali talks. Can we get the old woman from Airplane? That old woman from Airplane was the mother on Leave It to Beaver. That's why it was extra funny. That was Beaver. That was Beaver, Wally and Beave's mom. That's why it was extra funny.
Oh.
So yeah, that was Mrs. Cleaver from Leave It to Beaver. Old show.
I don't rob. I don't do nothing.
Ending at 11:47. Prior to this call or hearing any of these calls, had you taken out any warrants on anyone in this case?
No.
Okay. And before hearing the entirety of this call, did you have?
Oh, I forgot to tell you, Jeff. This alleged this robbery that took place in September of 2013. None of the defendants in this trial was ever charged for it.
Okay.
Other people were, and they were convicted, but not them. But they are playing it as an underlying act in the RICO charge to show that these who were convicted was associated with the
They're all
defendants.
in it together.
They are all in it together. Which, I mean, all these RICO trials in Georgia is quite ironic because the best evidence I've heard so far regarding anything close to RICO is the district attorney Fannie Willis screwing with her boyfriend.
Literally. Yeah.
Yeah. And hey, let's hire my boyfriend for this high salary so he can get me on good trips. That's actually good evidence for RICO.
Yeah.
This pile of manure, not so much. You know, in most trials, you start out with your best, or so imprint it into the jury. Then you have a midsection with all the boring facts, and then you end with something smashing. Yeah. So far, this has been incredibly bad. and it's getting worse.
Fair enough.
Yep.
Any awareness of who the driver was of this red Nissan?
It was still a mystery.
When was the first time that you learned that Adrian B?
Oh, yeah. From the time of the accident to his involvement and started to get out charges, the driver was changed from a large-chested woman with a blonde wig to a 6'3" man with dreads.
Could be the same person. Anyway, okay.
The car belonged and was owned by a woman with allegedly with a good rack, but she was never. They never looked for her. It was more interesting to get the witnesses to change the story to fit in more with getting other people in. Yeah. If anything have taught me in this trial, it is Atlanta Police Department in the 2010s corrupt as fuck.
He was the driver of this vehicle.
When I checked him out of jail.
Okay. Did you hear him talk about it with any jail calls?
Yes, ma'am. So I listened to the jail call, which caused me to go check him out of jail. I wanted to hear from him personally.
Okay.
Adrian is Adrian Bean. So this guy went to jail and checked him out. That normally is when you have an informant, a confidential informant, which most of us believe, oh, Adrian told stories to get himself out of trouble. And oh God, he told stories. But it's not entered into evidence as a truth of the matter.
Sure, of course not.
Except when it does.
Yeah.
Right. Your Honor, the state's ready to play 175 Charlie Bravo.
Yeah. And this is the one portion where Adrian
get
Bean's
transcript for
wife
that? Yes.
refers to
Lieutenant
a
Walker,
third
handles that,
party
please.
who think Thug was involved. But it's they are not bringing it in under hearsay. It's not for the truth of the matter.
And Your Honor, I put out a copy.
Hey! Shannon became a member. Thank you so much, Anne. Yay! You now have access to all my members-only content and to my Discord. And for the rest of you who may be thinking about it, $3 a month and you get access to all of it. Maybe not everything, but most of it. I will not stand up. I will not stand up, but pants are prison.
Does everybody have a copy? Which is you see fit.
Thank you, Your Honor.
This is a free.
Legendary Racing gifted 5 memberships. Thank you so much. Luke C. Legal Vices. Jeff, you remember?
Woohoo! Yay me! I thought I already was.
And to himself, to Ginver and Silent PS. Welcome to Vikings saying hi.
Yeah.
Call from
Bing.
an inmate at Fulton
Oh, and the wall of
County
doom.
Jail. This call is subject to recording and monitoring. To accept this free call, press 1. To refuse this free call, press 2. Thank you for using Securus. You may start the conversation now.
Yeah, and here's every Yale call starts with that. This will be recorded. And then they talk. And they talk.
Hey, babe.
Wait, do they have her phone up on there?
Yeah, I think they cut it out. They hung up.
Yeah.
How you feeling? Yeah.
Man, bad as hell. I got a big ass knot on my head. Got their stones getting up. Everything just going wrong right now. I don't know, man. This shit crazy.
I'm saying, I'm trying to cope with it, babe. I'm saying.
It good. I got shit with a damn suspended license shit, and then that shit won't fuck that door out of other shit yesterday. Ain't shit on me on that. I ain't got no charges about that shit. It just got me what the shit that I done did. That's all.
My big little home for about a year.
Ah,
I got a lot out of that.
yeah. Oh, I'm just going to speed through the rest of the recording because it's just garbage, and she will ask the detective anyways. And the Wall of Doom. Come on. Oh. Let's see if I have. Come on.
It's probably my
Seriously?
fault somehow.
Yeah, it is. Where are we? 144. Refresh.
I ain't got no charges about that shit.
Oh, we just heard.
Correct.
And from this call, based upon what he was saying within the call, could you tell if he was still in the booking area or if he had made it into population?
I'm not 100% where he was, but I don't think he made it.
Okay. Then is that based on what you
Oh, for fuck's sake.
heard?
Based off what I heard, yes.
All right. We're going to look at 2 minutes or begin at 2 minutes and 14 seconds.
And I don't care. And then they have their break. And he's back.
And again, did you hear when in that portion of the call where Adrian being discussed is getting Skateboard's car?
Yes.
Had that also come up in your investigation at this point in time when you're listening to these jail calls?
Yes, ma'am.
And again, are you looking back at our chart from the other day? Are these jail calls relatively somewhere between 9/11 when Mr. Bean was arrested to sometime in 9/16 when you heard or started actually listening to these jail calls?
Yeah, they are trying to make us believe that this detective, who was the lead detective in the robbery, spoke to 2 of the 3 suspects, but he didn't talk to the 3rd suspect until a week later. While yeah, because Mr. Bean referred in one of the recordings with Mr. Quinn that he lied to the cops at a hospital. But there are no recordings, there are no notes, no nothing. So Attorney Steele have said
Again, more coincidence. All right.
Yeah, there has to be, because it's referred back to. And the state says there is nothing there. Nobody talked to him. There's no evidence of it. Yes, there is, says Mr. Steele. You hear Mr. Bean talk about it. And the judge rules, no, there's not enough evidence that something was done back at the hospital. Yeah, we have a strong suspicion that this judge might be a tiny, tiny bit biased. Because sometimes when the defense have a motion to suppress or a motion to something, it's the defense who argues with the judge to the point where sometimes the defense says, can we hear from the state as well? Because the judge is making the argument for the state.
Well, somebody needs to. Apparently they're not making it for themselves.
Yeah, but when the state does, they nag the ever-living freak out of this judge.
Yeah, that's about it, yes.
Your Honor, say be ready to publish 175 Charlie Delta.
All right.
Yeah. And the evidence is called 175 Charlie Charlie, Charlie Delta, and Charlie Charlie Foxtrot. Because why make it easy?
Yeah.
It's right there. Something back in here. For a moment.
Yes, ma'am.
Speeding through.
Remember my admonition I've given you already. We'll collect those up when we're finished.
And Your Honor, say like the tender, say to the 175 Charlie Delta Tango for the record on.
Any further objection
Oh,
to
Charlie
states
Delta Tango.
175 Charlie Delta Tango? It otherwise has not been made already? All right, I'll note that it's continuing objection for the reasons we stated earlier. It's admitted and may be published as you see fit.
Thank you, Your Honor, and we'll be publishing approximately 3 minutes and 16 seconds, starting at 3 minutes and 16 seconds.
Sorry, what, madam?
Approximately 3 minutes and 16 seconds.
Now, I do know that there will be an interview later that is a bit more haunting.
Yep. I have an extra one for you.
And I'm going to speed through it because...
Thanks.
All right, so noted.
So what have you been up to, Jeff?
Nothing. Just working and doing YouTube.
Yay! Yep, me too.
And now seems like a good time to head to sleep.
Yeah, I got my golden bonnet on because
See that?
Megan
All the
Fox.
transcript's been taken up. All right, thank you, sir.
All right. Well, they're
What
getting all
time
the
is it at your
transcript.
place?
It is 1 a.m. It's time for
1
me to
a.m.
get to sleep so I can wake up in a few hours.
And go to work and then go back and
Yep. Do it again.
do it again. Yeah.
Thanks for having me here for a brief period of time to explain the
Th-
weirdness of today.
Yeah, and thank you so much for bringing people over for the more frustration.
My pleasure. Everyone stay here and enjoy the frustration. You had it from me, now get it from Nick.
Yeah.
Have a good evening, brother. We'll see you soon.
See you soon. Bye-bye.
Bye.
Oh,
Detective Quinn, again, and listen to that final call or that last call that we played, again, was there information contained within that call that was consistent with the investigation that you were investigating at that point in time?
Yes.
Right. Now, we talked about whether or not you had ever met Adrian Bean prior to listening to these calls. Prior to listening to the jail calls, to your knowledge, did anyone speak with Adrian Bean about what happened?
Not to my knowledge.
You testified earlier when you were here 2 or 3 days ago that you had sent Calhoun or Lewis, the two detectives, down to Grady Hospital to speak with both Prothro and Murphy.
Correct.
To your knowledge, did Lewis or Calhoun ever speak with Adrian Bean while he was at Grady?
Not to my knowledge.
and for information, those are the same cops who said there were no surveillance video. They didn't see any surveillance camera. But in evidence, there is crime scene photos of the scene with a surveillance video pointing right at the scene. And in the radio traffic between cops at the time, which for some reason they forgot to delete, they are referring to the surveillance video, and we hear them talking about watching the surveillance video. Isn't that strange? The surveillance video, nobody so far on the stand acknowledges, but the defense brought up and said, they are actually talking about the surveillance video and watching it. And these are the same cops we are supposed to believe didn't talk to Adrian Bean at the hospital. Isn't that strange?
Excuse me, when Detective Lewis and Detective Calhoun spoke with Murphy and Prothrow, did they provide you a report about their conversation or interactions with both Prothrow and Murphy?
Yeah, they both gave me some written documentation as to what happened.
All right. Let me ask you this. I think you testified earlier that you may have been aware of Adrian Bean going down to Grady. When you first got on scene, who did you know definitely went down to Grady Hospital?
Walter Murphy and Frederick Prothrow.
All right. At that time, had you had any information about Adrian Bean going down to Grady Hospital?
Your previous question at that time.
I can clarify.
I'll sustain the questions to form, and you can rephrase it now.
When you got to the scene on September 11, 2013, did you have any information that Adrian Bean had went down to Grady Hospital?
I did.
You said you did not.
I didn't know.
Okay. As the day progressed and you were interviewing Flora Nava Flores, Brian Ransom, going to all the different scenes, did you receive any information of Adrian Bean going down to Grady Hospital?
I got information that he had gone in, but he had also gone to jail.
Okay. And did you ever send anyone down to Grady specifically to speak to Adrian Bean?
Not at all.
To your knowledge, did any of the zone detectives or sergeants with Zone 3 ever go down to Grady Hospital and speak with Adrian Bean?
Not at all. Nothing was reported back to me.
Then how the fuck did he get to the hospital from the crime scene? Mr. Bean seems to claim in the recordings he doesn't remember that he was driven there by law enforcement. But these guys on the stand have the same amount of good memory as Mr. Bean.
And would you, if that would have occurred, would you be the person it would come back to?
Yeah, I'm pretty much running the show, but they had to bring it to me.
We talked about the homicide detectives. Did you ever instruct any of the zone detectives or zone sergeants to go down and speak to Adrian Bean at Grady Memorial?
I did not.
And would you have instructed any of the zone detectives or zone sergeants to go talk to Adrian Bean at Grady Memorial Hospital?
If I thought he was there, I would have. At that point, my understanding was he had gone to jail.
Now, after hearing those jail calls, what, if anything, did you do as part of your investigation?
Well, there was a lot of stuff in this information that was coming off on the jail calls, so I wanted to get a face-to-face, upfront interview with Adrian Bean.
Okay. And how did you go about attempting to get a face-to-face interview with Adrian Bean?
I went and got a court order, which is procedural, to get an inmate taken out of the Fulton County Jail, namely Mr. Bean, and have him brought over to the homicide office. I was going to do the transport myself.
Okay.
How about that? That brings us to sidebar counter 111. Oh. Okay, speed through.
You may proceed, ma'am.
Thank you, Your Honor. I'll show you what the market states exhibit 177C. Tell me if you recognize exhibit 177C.
This is the court order I put together on the 16th of September, 2013.
And does that appear to be a fair and accurate depiction of the court order that you drafted in order to get Mr. Adrian Bean from the Fulton County Jail?
Yes, ma'am.
Your Honor, this time the state would like the tender states exhibit 177C into evidence.
It's submitted over defense objection. There'll be a continuing objection, may be published as you see fit.
Thank you, Your Honor. Can it get bigger? Now, looking at State's Exhibit 177C, what date did you go and pick up Mr. Adrian Bean from the Fulton County Jail?
September the 17th, 2013.
And about what time did you pick him up? Do you remember?
It was between 9 and 10. It might have been 10:30.
And is that based upon the order that was signed for you to be able to pick him up?
That was the window that I gave to the judge.
Just a few questions here. Now, this officer claims he knew nothing about Mr. Bean. Nothing. But if he didn't realize he was at the Brady Hospital, didn't know he might have been involved in this, why did he listen in to those jail calls? Why did he get him out of jail to have an interview? What led him to Mr. Bean? And because it looks like it was out of the blue, completely, that all of a sudden, hey, there's a Mr. Bean in jail. I need to talk to him. No, wait a minute. I will listen to, maybe he has some jailhouse calls first. Yeah.
And again, when you went to go pick him up from the jail, would that be your first time meeting Mr. Bean?
Yes, ma'am, it was.
All right. Now, do you know why he was in custody?
He had a probation violation or some previous interaction with the law. I don't know exactly what it was. I didn't want to know, really. I just knew he was in jail.
Why didn't you want to know?
Because I don't like people, when I'm working an investigation, I don't want to get into the minutia of what they may have been charged with previously. I don't want to get into that.
And again, at this point, had you had any warrants for Adrian Bean as it relates to what you were investigating?
Nah, not at all.
And were you able to get him from the Fulton County Jail?
I was.
And did you bring him back to, where did you take him?
I took him to Atlanta Public Safety Headquarters.
And where's that located?
That's it. It's been some years. 600 block of Peachtree.
Okay. 220, does 226 Peachtree sound familiar?
Okay, you're right. I'm thinking of the old headquarters.
When you interviewed him, was he cooperative?
Oh, yeah.
Right.
Of course he was cooperative.
Did he speak with you about what
You
happened?
were his ticket out of jail.
Right. Did he speak with you about who was involved?
Yes, he did.
Was he able to give you details about the incident?
Again, how did you find out about Mr. Bean if you never talked to him before, didn't know who he was, and he was in jail for some violation? Yeah, I mean, we are missing one step here. How did Mr. Quinn find out about Mr. Bean enough for him to listen to the jailhouse calls? Yeah, I know who Red Fox is, Jeff, and the chap last week said the same thing. Let's see here. Let's see if we can.
I'll get that. Hello, Fred. Hello, Woody. Goodbye, Woody.
Hey, come on in, Uncle Woody. You too on this, man.
Not until that heathen apologizes for slamming the door in my face.
She's right, Pop. Apologize.
I apologize as to slamming the door in your face.
Well, that's better.
Yeah, sounds like Red Fox.
He was.
Was he able to identify who the fourth person in the car was?
He was.
Now, was his interview recorded?
Videotape and audio tape.
And when we first talked about audio tape, when did you first begin your audio tape version of this interview?
Like always, it's customary when I get down. I always activate my tape whenever I put whoever I'm picking up from the jail in this lapel pocket right here. And we're live. And I keep it that way live all the way to the time we get back to the jail. But I actually put on video when we got to the headquarters and had both going at the same time. Again, that belt and suspenders thing. I just want to make sure I catch it.
Why do you keep on your pocket recorder from the time you pick him up from jail to the time you return him back to the jail?
I want everybody to know I'm keeping it 100. You know, not missing anything.
Sure. But your best friend, Mr. Velasquez, didn't. And I don't trust you, Mr. Quinn.
And have you had the opportunity to listen to and watch the interview with Adrian Bean in preparation for this trial?
I have.
Permission to approach.
You may have already shown to the defense counsel.
Yes, 176 Charlie Alpha has already been admitted, Your Honor. And I'm going to approach with 176 Charlie Bravo.
If you just joined, remember
First show
to
you
hit
for-
the thumbs
first
up
you have your hand
and subscribe
up
if
with
you haven't yet.
176 Charlie Bravo.
Okay,
Do you recognize Exhibit 176 Charlie Bravo?
I do.
How do you recognize Exhibit 176 Charlie Bravo?
It's got my initials on it. It's got Adrian Bean's name, visual interview.
And is that a fair and accurate depiction of the video of the interview that you did with Adrian Bean back on September 17, 2013?
It is.
Now, looking at 176 Charlie Alpha that's already been admitted, do you recognize Exhibit 176 Charlie Alpha?
I do.
And how do you recognize it?
It's flash drive. It's got my initials on it, dated with a date and everything.
Okay. And did that appear to be a fair and accurate depiction of the audio portion of your interview with Adrian Bean on September 17, 2013?
Yes, ma'am.
You're at this time, the state would like to tender State's Exhibit 176B into evidence. 176, Charlie Bravo.
All right. A bunch of people having birthdays. I see Jesse. Who else had one? Ah, Rachel. Ah, two people at least. Happy birthday to you. Happy birthday to you. Happy birthday, dear Vicky and Rachel. Happy birthday to you.
All right, any objection to states 176 Charlie Bravo?
It's cumulative. It's the same thing like the last time.
I'll rule your objection on both grounds. It may, I'm going to admit, states 176 Charlie Bravo over objection may be published as you see fit.
Thank you, Your Honor. And Your Honor, permission to sit during this portion.
You may not.
Thank you.
What are you doing under the desk,
Yes,
Detective
Mr.
Quinn?
Sharp. All right, noted and overruled.
And Detective Quinn for the
They're always after my lucky charms, aren't they?
audio portion, I'm on portions, so I'm only going to publish a portion of the audio portion.
Yes, ma'am.
Yeah, for you who don't know, I may or may not have relatives in Ireland from 1,000 years ago or something, maybe not voluntarily. Jesus Christ.
Right at this gate right here. Good morning, Lieutenant. How's it going? That's my raggedy ass tourist straight ahead. Why you say that? You don't like that? It's a free car. I'm not mad at it, you know. Free gas, pick the groceries up, take the kids to the soccer games on the weekend, which is against the rule, but you know, we don't make no money. But you get used to that. Y'all getting paid. Y'all get good. No, we don't, man. Not even, man. I'm just glad to be employed, my brother, and be healthy. Take care of the family, you know what I'm saying? Like you. You're a family man. You're a good family man. For to make sure my family, pray. Yeah. Oh, that's it.
We're going to stop it at about 55. It was 55:12. Is that you on the recording?
It is.
And at what part of the recording are we listening to?
This is actually getting into my Ford Taurus, my take-home car.
All right.
Why is that necessary? We already know he spoke. This is the prosecution wasting time. Now, there are interesting recordings. There are interesting parts of recordings. And there's pure bull crap to make this guy look like a good guy.
And what we're going to do actually is just, do you get in the car and take him to 170?
Another recording.
All right.
Bria, the point of that was to make this witness look better. That's it. You're not supposed to do that. It's called embellishing, but it's allowed in this court because this judge is biased. What the frick? Okay, here we go to the jailhouse when the interview in the police precinct, I
Before we
assume.
begin, can you tell the jurors what they're looking at in State's Exhibit 176, Charlie Bravo?
This is the interior of one of the interview rooms at Public Safety Headquarters in the homicide unit. That's Mr. Adrian Bean sitting there waiting on me to walk in.
And what is he doing? Can you tell?
I think he's eating. Okay, I can't really tell what he's doing.
Pull it up on the page.
Skipping ahead a bit. And technical issues in the courtroom. Here we go again. Skipping ahead. Are we just going to sit and watch him for? Oh, there he is.
I got the thing. But you know, it was all a mystery to me. The bosses always want you to lock somebody up immediately, but that's not how I operate, man, because I'm the one that has to testify to every fucking thing goes on there, you know what I mean? Plus, I respect the rights of the people who we believe are significantly involved. I mean, you got families, you got rights. And I believe that if I don't do a thorough job, I'm basically saying, fuck your rights, you know? I don't get all excited because the police officer been involved in the shoot. I'm glad he's okay. I'm glad nobody really got fucked up too bad. But I got a little problem with what you kind of told me in the car. I want to make sure you got your story right about why you were up there at Summerdale Commons Apartments. Make sure we have that right. I need you to think hard about that day. Remember from start to finish. Again, tell me to get rock. Tell me, Quinn, I'm fuck you. I want to go back to where you just brought me from. I mean, I'm just going to make sure I got it right and I respect you because I don't want you coming up later talking about, you know, like we were talking about in the car, people always come back later talking about stuff. It's too late. Now, too late is kind of open-ended when you say that. I can't really change the outcome of anything. All I can do is take the truth to the DA and say, okay, out of all four of these people, only three of which I know of, this one told the truth based on what I've done. That's all I can do. I can't say, okay, I can't tell anybody, I can't make any decisions. I don't have any power when it comes to all I can do is impress upon the people that handle the prosecution. Like the DA's always telling them the truth. Personally, I think the one down at the And Grady healing up, I think they lied. I mean, you lied a little bit too, but I want to clear that up.
You lied a little bit too, in context with the people lying down at Brady.
Based on my investigation, I'll show you why in a minute, but run down for me how this whole thing started. How did you end up with that burgundy or red Nissan Altima that white kid named? You know his real name, boy. You know his real name?
Ah, Nana Mr. gifted 5 memberships. Thank you so much. It went to Jesse McCleverty, Michael Burke, Susan Lee, Penilla, and Stacey Ann. Welcome and welcome back as members on my channel. You now have, again, and for the first time, access to all my members-only content. Thank you so much, Nana. That's very, very nice of you. Am I green? Let's see here. Nope. I am unlimited. So, yep, this stream just got demonetized. Ta-da!
Oh, man. Okay, Brian, been on for. How long you know? Been on Brian a couple of years. Okay.
Stop.
That's good, because he said 2 years, so that's right on time. Brian Ransom. Mm-hmm. Did you know the Mexican kid was with him? No, he came with Brian a couple of times. Run down for me, 9/11/2013. How you ended up with that car, and how did you end up skinned up the way you are? Just start where you got the car and head there, and then I'm gonna tell you what I got. Okay, cool. Let me first. Okay, no. The day we pulled up at the spot. I pulled up at the spot. What's your spot? Talk about this on Make It Drive. When I pulled up down on Make It Drive. What's that address? What you probably seen a black camera on. I can't really remember the address. Both the spots, because I got like 2 spots. But the first one of the spots that's across the street would be 2246, and I think the one over there is 2323. Maybe. Okay. That's okay. You know, where I met your wife was 2333, 2233. Okay. That's where I pulled in, Paul. About 15, 20, 30 minutes later, Brian pulled up. He called me and said, you need to come holler at me about something. I was like, okay, cool, bro. He pulled up and guys went up. Cool. Let me make sure I got these names right. Brian pulled up, and then what happened to Brian pulled up? You in the camera? Yeah, look, I pulled up and just shoot the shit for a minute. And Brian called me to come to see me. Like, come on, Brian, come chop it up with me or whatever. So Brian come, and guy on Thug roll up, said, hey man, I just seen a dude with about 30,000 on him. You know what I'm saying? Who's that? Who? That's what Young Thug said. Young Thug said, got the loop. Is he the kid that's with the dreadlocks? You don't think I'm around? Right. Real skinny though, wearing pants like white boys. Yeah, okay.
Now that's not good for Young Thug. This early on in the investigation, he was given up by Mr. Bean. Now, is Mr. Bean truthful, or are he just spitting out names to get himself out of trouble? I would say the latter. Just, I will give them a name they want, but I don't know what the jury will hear. But it's still not good, because that's Mr. Bean claiming it.
He's free. He's saying guys with money or whatever. Me and Big Fred, y'all go ahead on with that, man. Whatever. Y'all want to go do it. Y'all go do it. Use Brian code, whatever. You know what I mean? So they went to check on whatever was going on with that situation. So you guys had how much money was this? Seen who? He seen, I don't know who he said. He just seen the guy with money. And they went to check on the guy, whatever. They come back. Whatever. Who went to check on the guy? Him and the guy with the D and K face. DK, we call it DK for that. You know what I'm saying? So they go check on the guy or whatever, and then going on with that situation. So now the fact that they come back, now we all go in on some lean. You know what I'm saying? Okay, so we're gonna go get some lean. Okay, I go get it from a buddy up here in Somerville. Okay, cool. Well, you gonna go get the lean? I gotta feed it. Big Fred. He just come home. Fred, he ain't got nothing. He don't know nothing about nothing. He just come home, change that. So he like cool. And like Big Cody gonna ride with him. Okay, cool. Thug DK get in the back. Okay, cool. I'm driving around, call whatever. Woo, woo, woo. So we go up there, get DK the money. DK supposed to go get the lean, whatever. DK go around the corner, start firing some shots. Shots go up. He come back. I'm looking at DK like, what the hell going on? Like, what the fuck you shooting for? What you shooting at? You know what I'm saying? I'm telling all the way out. You know, what the fuck you shooting at? Why are you shooting?
And still, with this testimony or statement, Mr. Williams was never charged. Because it's literally, this is the only one claiming it. No other witness, no other evidence, no fingerprint, no DNA, no nothing says Mr. Williams was in that car. Only the snitch claims it. It should be more cumulative, it should be more prejudicial than probative, but in this court, this judge will let anything in that is even remotely relevant.
You know what I'm saying? He got the car, go. So when I get in the car, pull out, now he go, cars pull up. And when I pull out, what cars? It's like black car, blue, just like that shit you drove up in here. It's one of the cars, when I go around the car, whatever, no, wait, you want to rent the car, dude? I see his dad on the police car. They saying they got hit by your car. You remember that? Oh, I went around the car. As I go around the car. The car pull up. He trying to see what's going on with this. I'm trying to see why we're like, this is your head. This is your car. Are you back in the market? You bagged in. This is the front of the car. You bagged in? I'm bagged in. Cars come like this right here. Stop. Right now, about 2 cars lengths up. Okay, cool. I pulled out. As I pulled out, cops already right there with the gun. You see what I'm saying? I go around like this right here. As I go around like this, cops are hit me. Bump the tail of the car like that right there. I go out. They shoot. Boom. Cop. He 5 shots. I go around. Boom. Hit the gate. Boom. Go straight across. Jump over the wall. Boom. Hit the other wall. Boom. Run into the laundromat. After that, did you see that police car down there at the bottom of the wall? I didn't see no police car. It was back then. You almost landed up. So you were driving the car. Yes, sir. It was a lot of the case when they first came started, and I told you that's probably the lie you're talking about. I told him that Big Fred was riding all like that right there. I was the driver. Big Fred was the passenger. DK was behind me, and Young Thug was behind Big Fred. Young Thug is a rapper. Wait a minute. So Young Thug, what did he say, Fred? Because he's like 6'8", 354 pounds. He was sitting in the back seat. No, he's in front with me. Okay, so make sure I got the C-track. You said Big Fred when you're driving. All right, we got that cleared out. That was in the beginning. Yeah. So I told you boys, I ain't keep on with some things always out, man. You know what I'm saying? Big Fred. You know, I told the police officer, everything just happened so fast that we ain't even, none of this was even supposed to occur. You know, so my man just come on for it. So what about the guy with the money? Sir, what about this guy with the money? What's Thug came to you with a lick? It sound like, no, they want to check on the liquidate. I guess when DK got the car, you see any money on it? No, sir. I had $345 a month. Yeah, I know it's your property. I saw it down there. I had my own money sheet. Yes, I had my own $345 in check and worth of cash in my pocket. It had nothing to do with what was going on up in Summerdale. No, sir. Did you know that DK got some money? Well, let me ask you something. Who had pistols in that car? Make sure I got in the car correct. Who had pistols in the car? You got Big Fred with a gun? You got DK with a gun? You got Thug with a gun? Big Fred, what kind of gun did Big Fred have? Don't go get it. I think you can recognize it. He has a 9mm Fred had a 9mm Ruger. Don't slow for me, don't slow. Okay. DK had a little bit small, little gray looking gun. You know what kind? I don't know. Small and gray? Yes, sir. Was it automatic or was it I was in love, man. All right, you don't know what his was 9, 40, 45? What kind did he get? I can't tell you. Okay. I don't hang. All right, small gray automatic. Let me put it on the silver wrap too. These are young guys to me and Big Fred. Like I said, Big Fred just come home from jail. I'm trying to show him big home in a good time. I took him to buy brand new clothes and stuff. Okay. You know what I mean? And that was that. Big Fred, young guys, I don't know what they be having, what their things is, what they be on, whatever. But they is way beyond what we're on. You know what I'm saying? They go buy a whole nother meal to get their money. That's for sure. To get my money. The young other guys, they like to rob, take, and do all this other stuff. Okay, enough. Okay. I don't want to put that clip, you know what I mean? I never rob, I ain't got no rapping, no robbery and stuff, the juvenile, or something like that, but since that, I've been straightforward. You know what I mean? Trying to raise my family and whatever. What kind of gun a young thug got? You remember? I didn't see thugs. Okay, but how do you know they had one? He had a keep gun on. How much was the lien going to be? How much was they paying for the lien? Here's your pop. Was it $150 for the lien? 50?
If you stand member for 8 months, don't worry, be happy, Nick. Yeah, okay.
No, I gave him 50. And he went 50, Phil went 50, and DJ both went 50. Both all going on lean, both show big for a good time. That's it. Did you know that, how long did you know DK? For a week. That's it. It's not even the neighborhood. Just a couple weeks. I've been hearing about him and stuff like that as far as this, you know, just running with him, hanging with him. But that was on the second time that you got in the car with him? Yes, sir. Okay, well, I want to make sure we got the right DK. Because when he got down there, if you don't know him off the rip, let me see how. Okay, describe DK for me. The guy in the car with you. And where did he sit? You just got a tattoo, the D and a K on the forehead. What's that all about? Back with K. I don't know, probably. They the gangbangers and we gangbanger family man, or guys that come home free. So you know what I'm saying? So DK, who's he praying with in the car? Those big guys with each other. They gangbang, they fire themselves sometimes blood. How long you known Thug? I know his father. I've been on his father over a couple of years now. You know what I mean? I said, Thug just started coming around. But how long you know he exists as a human being? How long you know the rest? I can't. How long? I can't remember. In years. Scared to guess. Because I don't know what the real name. What the real name is? Lil Jeff. That's all I like to call him. Lil Jeff. You don't know his last name. What is that last name? I don't know his last name. I know his last name. Jeff Rowe. Lil Jeff. Jeff. Okay. I'll figure that out for you. So the guy in the car with you is Kid DK. You saw a picture of him, you recognize him? Yes, sir. All right. Now I got a picture of a kid named DK. Got a DK with a backwards camera report. Is that the DK that got in your car? That's the one that got in the car? All right, back seat. DK in the back seat. All right. Now, I want you to listen to something. And then, I want to make sure we got this story right. Did you know the DK had a lot of money on him when we got it in the pocket? Bloody money, which means it got wet up when he. Okay. Everybody else said there was some shots in the car that was crashing. What's that all about? I heard a couple shots as we were going bumping up and down. You know what I'm saying? Do you know that y'all went off that wall? Yes, sir. How did that happen? What the goal is going out of control. It wasn't breaking the floor. It wasn't breaking that after the gate hit. The car is going. Because he went on that grass and did his own thing. He went straight to that wall. Ain't no stir, no acceleration, no none of it. It's just going. No magic gas, nothing. It just because he did his own thing. So.
Yeah. Atheist and when I grow up, I want to be chill and like Nick. I'm currently in my grumpy a-hole phase. When I retire, I'm going to spend a lot of time on my front porch, smoking a cigar, having a beverage, and screaming at people to get off my lawn. That is a big plan of mine when I eventually retire. I will try to become the grumpy old guy. I see the discussion about why is this cop wanting to be so friendly with him? Because I don't know. He might know about Mr. Bean before. He knows he's easy to get information from. He will tell you anything you want him to say because he will always try to get out of jail first. So he will give up anyone to stay out of jail.
You remember what I said about taking my time with this shit? Just listen. Working on what I need to be working on. That's what we gonna be. Instead of giving no boy today, because I got probation violation, I got to count back with his mouth. The old man say he ain't worried about it. Well, why ain't worried about it? Cool, they don't come to court, I go to court, they got it. I got to go back to court to get your show, I didn't know why you know everybody else. Just listen. But it hasn't been started the way anybody in my child. I hear about this. All my first people, I ain't down that about. If you really not gonna buy this, hey, you want my child. 30 years old, 30 years old.
And here they are playing the jailhouse call again. How did Mr. Quinn find out about these jailhouse calls? Because remember, they are only saved until somebody asks for it. So how did Mr. Quinn find out about Mr. Bean? At what point? Because this is just less than a week after the incident. How did he find out? That is a mystery, because there is Mr. Bean was arrested due to a parole violation, put on the hospital, put in jail, and somehow someone, hey, let's listen to his jailhouse calls. For what? He was on probation violation. Yeah, we already heard these recordings.
All right, thank you, sir. All right, ladies and gentlemen of the jury, the hour being about 5:20 on Friday.
Yeah, I sped through that because we already heard the interesting part. Mr. Snitch being a bean. I mean, Mr. Bean being a snitch, giving out names right and left. So let's see.
We're going to go ahead and recess for the evening at this point in time, okay? Detective Quinn, if you could come back this coming Monday, that would be the 25th for 9 o'clock, sir?
Yes, sir.
Okay, we'll see you then.
And let's see if they are having a hearing.
April and May. You're not, you.
Let's see what happened the last thing on Friday.
On the 29th, next Friday, I'll give you a couple of dates later in April and May, so you can plan some other dates just in case, okay?
Yeah, by the way, week after Easter, no trial. So next week, no trial. They are having the week off again. And then apparently they will have days off in May as well.
Other than those Fridays, it will be starting half day, okay? All right.
Excuse me, Judge, did you say half day on the 29th, next Friday?
No. You were listening to what you wanted to hear. No, I said I will tell you other dates applicable in April and May. You're not, you're gonna get in trouble. You're gonna be like 213. All right? No, I did not say that. We're working a full day on the 29th.
Full day on the 29th, which is what? Why would you have a full day on Long Friday? That's Easter. For you, on the 29th, by the way, I will have a fundraising stream regarding the Hales. So buckle up on Friday, because that will be funny as hell. And the return of the Wheel of Regrets. And yeah, this trial, this is witness number 40 out of 400. Yay. I mean, yeah, why would full day on the 29th? Why would they work a full day on an... I thought in the United States you celebrated Easter like the rest of us. Friday, Saturday, Sunday, Monday. Also, I thought. You tell me in the chat.
Okay? Huh?
Good Friday.
Yes, ma'am. The Lord will be just fine. Okay? All right. All right. Anything else?
Yeah, gives a time. That's Monday next week.
You all just don't listen. I know it's late. What did I say about that?
I'm saying
Next Friday, what am I going to do?
tell us for April and May. That's understood. For the week of next week, are we anticipating 9 a.m. starts?
Pretty much.
No, you won't anticipate a 9 a.m. start. Nana says I need to have friendlier options to my tummy. I mean, I'm Swedish. We eat pickled herring and licorice. I mean...
Yes, except for Thursday, the 28th. Thursday, 28th, we may have a delayed start around noon. Okay? More to follow on that. All right? No. Anything else? I'll bid you. See, Wayne, couple of things before we close up for the record for today. Ms. D. Williams, were you able to reach Ms. Abasi?
Be available on Thursday.
All right, that's Thursday, 28th.
Yeah. Easter was more sacred a few decades ago. You couldn't get us Swedes to stop celebrating a full Easter. And we are not even religious, but we do like our Easter.
On the 28th, and what I'll do is we'll cover that.
Yeah, timings are boring because he can't keep time if his life depended on it.
We will take up some motions on the 1st and the 2nd of April. That's Monday and Tuesday. At this point in time, I have...
Okay, so Monday and Tuesday, they will have motions hearings. I will do recap about them on Tuesday because I'm not doing fuck all on Monday. April 1st. Oh. April 1st. I might have something interesting to do, by the way.
There's a motion, Mr. Steele, number 2, motion to strike. I need to schedule that. So Mr. Steele and Ms. Estate, that's acceptable to you all. We'll take it. I'm just going to put it on probably for the 1st of April, that Monday. That work for you all? Mr. Steele? All right. And then also I have DeMontre Kendrick's motion to limit witnesses due to undue delay, waste of time, and or needless presentation, and the supplement that has been filed consistent with that. So, Mr. Weinstein, I assume that Mr. App is going to argue that since he filed it?
I believe I'm arguing that.
Oh, okay.
But I'll confirm that with Mr. App.
All right. Well, between the two of you and Ms. Hingerty, one of the three of you should plan to argue that motion on the 1st, okay?
Yes, Your Honor.
All right. Okay.
Yeah, that could be really
Mr.
interesting
Steele, I'm
to
still in
listen
possession
of,
of...
because they pointed out in that motion that if the state keeps its current with 10 witnesses per month, we will be here until 2027.
Motion limiting number 44, which is apparently... Did we ever finish that, or do we even consider it? Because it's involving some statements that were allegedly made by your client to Detective Quinn.
That was excluded. I'm not looking at the motion right now, but if that's what it is, that was excluded already.
It's September 11th of 2013. Mr. Williams to Detective Quinn while he's working an extra job at Neiman Marcus at Atlantic Mall.
Okay, we did not hear that. You are correct.
All right. Is that going to come up in this particular examination of detective? I mean, I believe that will it come up before?
Yeah, and they still haven't heard the motion about the Georgia Supreme Court decision that certain lyrics and music videos are not allowed as evidence because it has the free speech, the First Amendment. That was a decision in the Georgia Supreme Court about 2 weeks ago. So they should get there anytime soon.
But then, I mean,
I would say yes, but unless the state's not going to use it, I would say yes.
all right, then we need to still take it up. So this is what kind of I cite routinely to.
If you're going to blame the defense because of the length of this trial, no, Mr. Glanville, you need to look into a mirror. The only reason this trial is as long as it is because of you. Hi, Tamery.
Do it earlier on Monday, since it's going to come out Monday.
The way that the court has ruled, I assume it applies to everyone because that's how we've been ruling, but no, it was only Mr. Williams and former Detective Quinn. It is not custodial.
Is it argument?
Yes. Well, I mean, you can hear what the statement is, and then yes, argument. It's Detective Quinn approached Mr. Williams, or Mr. Williams and former Detective Quinn met at the store, and there was a conversation. Detective Quinn brought up the incident you're hearing now, and he said something like, "I'm not looking at my notes. I am prepared. I'm not looking at my notes." Something to the effect of, "If I find your DNA on the firearm, I'm going to arrest you." That may not be a quote. I'm not looking at anything. Something like that.
Is there a statement that the state's turned over to you?
Yeah, they turned it over recently. And I think Detective.
Yeah. Again, prosecution had this conversation in their hands for 11 years or 10 and a half years, and just recently they turned it over.
Quinn, I may be wrong, gave it to the state recently, and then the state gave it to me, or maybe to everybody. And then I'm saying that the silence used to be you can't comment on someone's silence. That changed. I believe it's ORR versus safe. But now it's in the court's discretion under a 403 or 24-403 balancing test. That's why I filed the motion.
What's the citation for or?
Give me 1 second if you don't mind. I should have put it in the motion.
You did, sir. Thank you. You did. 305 Georgia 729 pinpoint. I should say head note 4. All right.
So in Georgia, silence can be an inference of guilt when confronted with a police officer. Great.
All right,
Yes.
let's take that up at 8:45.
Yeah, yes, this judge has a military background. But his military background is helping out forming the judicial system in Afghanistan. And during that time, he got PTSD. So, did Mr. Steele ever file his motion to recuse this judge? He should do it before today, I think. So it should be on today's thingy.
On Monday, okay?
Thank you, Your Honor.
All right, let me stop that. Do this while I find today's. Bum, bum, ba. Dun, dun, dun. Going to play from 11 Alive instead for. Bum, bum, ba.
Can you just take your drugs in?
Oh no, they don't have closed captions. Sorry. Let's find that one.
This motion, if that's okay.
Let's see here. There you are. There he is.
16-4, A1, as well as 17.
All right.
Good morning,
We
Your
are
Honor.
up to
Good morning,
day 48.
everyone. Your Honor, I'd just like you to take note and then consider the following. These statements should have been given to Mr. Williams 10 days before trial. That's pursuant to OCGA section 17-16-4, A1, as well as 17-16-7. Detective Quinn, I believe, qualifies as a person who is on the prosecution team, so he's part, and it's imputed knowledge to the prosecution. I have no issue with Ms. Hilton's statements at all that she found out about it on or around December 29, 2023. I'm not saying that Ms. Hilton intentionally did not give it over, but it's broader than just when the line district attorney finds out about it. With that being said, Your Honor, I have, and I'd like to mark just for your consideration, if it's okay, the information that we were.
Okay, it seems like Detective Quinn had information he didn't share even with the prosecution until just before New Year's, in the middle of the trial. And that is way over the limit of discovery. Way over.
Provided, dated December 23rd, 2023, for purposes of this motion, if that's okay?
Yes, sir.
All right. Can I have a pen?
I'll just mark it as next course exhibit in order.
Okay.
For the purposes of motion. You can hand that to Ms. Weaver.
Thank you, sir.
Yeah, I agree with Patty. Don't care if Thug did any of this or not. It's about getting a fair trial.
There's no.
Hi, sir.
So, Your Honor, these are presumably there's no ripping, there's no memorandum, there's no report, there's no summary. So this is going a 10-year memory of Detective Quinn. And if you admit them with the issues that I've raised, if you admit that Detective Quinn can do it, I also don't want this to be expanded because I have no way of checking, verifying something from 2013. And in Orr, which is State versus Orr 305, Georgia, 729, it's Division 4, 2019. It's at the end of the opinion. The highest court wrote that in most instances, silence is so ambiguous that it is of little probative force, especially if the defendant does not later testify inconsistently. And all I'm raising is something happens on the witness stand. I have no notice of any other statement. I have no way of verifying it. If the court admits it, I'd like it to be bound tightly to interaction 1, 2, 3, and 4. But based upon the late notice, not blaming at all District Attorney President Hilton, I'm just saying the late notice under the statute, it should have been given 10 days before trial. And because this is coming from nothing, I mean, I have nothing of to check this, verify it. So there's no report. So it's a 10-year-old memory, now 11-year-old memory.
So Detective Quinn wants to say something he claims he remembers. Now, again, Detective Quinn with his best friend, former Detective Velasquez. And you all know, Detective Velasquez is a crooked cop who destroys evidence. Exactly, Heather. There's literally no record of these statements, and it has not been turned over until in the middle of the trial to the defense. This alone should be a disqualification of this witness, in my opinion. Because why would we ever entertain the idea of bringing it in?
This was December, you found out about December of 2023?
Yes, Your Honor.
All right. Mr. And then you got the statement sometime thereafter. Is that correct, Mr. Steele?
Sure.
Have you all had an opportunity to talk with Detective Quinn about that interaction, purported interaction with Mr. Williams?
I did not. I have had opportunities to speak with former Detective Quinn, but I've not asked him about these statements. I thought that we'd take it to this court first, but I did not do that. Anyway, those are my my issues with that. I also, if you admit it, in interaction number 4, Mr. Williams is again with Mr. Walter Murphy, according to Detective Quinn, who identifies, I presume, Walter Murphy, or will recognize Walter Murphy in front of the jury. And that again bleeds over to my request that you take in consideration not to admit the May 12, 2013 supposed armed robbery involving, and I'm just using initials, Miss A.B., that I've argued before. You've denied it, but it's being admitted, I presume, for association, and it's not an overt act. The district attorney's office position is an overt act doesn't have to be charged, and it automatically comes in. I can't find any case that supports that. So this is another, I offered to stipulate that the two associated, but it's just another example of why the other act does not need to come in. But I hope I'm making myself clear. I didn't get proper notice. I'm not saying that the prosecution had the proper notice. I'm just saying that former Detective Quinn is on the prosecution team, so it's imputed. And that at this point in time, it always happens. I'm not blaming anyone, but it's going to become potentially expanded. Or Mr. Williams, I told him this and he didn't make a statement, and the silence is ambiguous and generally no probative value. And that's out of the State versus Orr case.
All right.
And it changed the law from Mallory, M-A-L-L-O-R-Y versus State, where it was automatically out of silence. So that's it. That's my argument. Excluded as too prejudicial rather than probative. But that law changed.
Okay, where in Orr are you talking about, Mr. Steele?
Very end.
At the very end?
If you go to the very end of the opinion, and I'm not saying that we're looking at the same opinions, but if Your Honor goes to, if you see the very end of the opinion, you'll have, it's going upwards, so you're going backwards, you'll have C. You'll see the last paragraph, it starts with a C, as in Colette, Charlie. And then if you go above that, you'll start with another paragraph, but we also recall, and if you go above that to the next paragraph, that's where it is. It's in the indent. It starts with, we have consistently doubted the probative value in criminal trials of evidence that the accused fled from the scene of an actual supposed, hold on one second, Your Honor, hold on one second. I'm sorry, it's in the paragraph above that. It starts with, it should be reiterated, if you can find that, Your Honor,
Yes.
that the exercise of discretion under 403 is a case specific. I lost my place, hold on. And usually turns on the trial court's assessment of probative value and prejudicial effect of the particular evidence. In this respect, we note that the United States Supreme Court admonition that in most instances, silence is so ambiguous that it is of little probative force, especially if the defendant does not later testify inconsistently. That's where I took that from. Those are, I'll answer any questions.
At best,
I'm just
anticipating. At best, this can only be admitted as a rebuttal, but they want it in during their case in chief, which I don't understand why it's even entertained. I understand why the prosecution wants it in, because they are a product of Miss Fannie Willis, who, in my opinion, is a lying liar who lies and a cheating cheater who cheats. So anybody she hired is tainted by her.
That this is going to be a fluid situation. There's going to be more statements. There's going to be assertions made to Mr. Williams that he didn't answer that's not in here. And I just want to protect the record, and Mr. Williams, and make this objection. If you admit the evidence, I'd like it to be typed to.
Man, he can't. I would be troubled if there were other statements that were made that you around this, and that's why I asked you if you'd had the opportunity to interview him, so that sometimes when people recollect things,
He hasn't interviewed him because he doesn't want it in. He doesn't want you to have the excuse, well, you could have, well, you talked to him, you asked him about this, now it's getting in. No, Mr. Steele learned from his mistakes. And he's not going to talk to former Detective Quinn about this, because then he knows you will admit it. Because Gwendolyn, I'm confused. Doesn't the defendant have the right to remain silent? Yeah, but this was not, I don't think this is a statement done when he was under arrest. This is just a claim from Detective Quinn, a memory. There are no recordings whatsoever of this event. None. If I understand Mr. Steele correctly. Or if it can be that Detective Quinn just remembered, oh, I have this recording as well.
you know, the written certainly aspect is a portion of what they actually do remember. So that's why I asked you whether or not you had taken that opportunity to do so.
I understand.
Okay.
But those are my concerns. I wanted to raise them to your honorable court.
Okay. All right.
And to the district attorney.
All right. Let me hear from the state, and then I'll make a decision. So, Ms. Hilton, and so you all got Mr. Steele's first concern is under 1716.4A, et cetera, and then 1716.7. These statements should have been turned over 10 days prior to trial.
Yes, Your Honor. So first, I do want to address 1716.7 and 1764, and I want to direct the court to Watley v. State, which is 326, Georgia App 81, which is the 2014.
81, you said?
Yes, Your Honor.
Okay.
And it's a 2014 case. And specifically, we are in.
Yeah, I know, Heather. I know the judge will find a way to let it in, even though the case law the prosecution recites is vaguely connected to this specific issue. For
Maybe
me,
on page 87.
it's amazing that any court in the United States even entertains, whoopsie, I just remembered I want it in the middle of the trial. Too bad. Off you fuck.
Your Honor, and what Watley states is that the statutory obligation of 1716.7 is not triggered when a witness merely makes an oral statement. There can be no possession, custody, or control of a witness statement, which has neither been recorded nor committed to writing. So, Your Honor, in this case, there was no previous written or recorded statement about what Detective Quinn told the state. It actually came up very organically as we were preparing for testimony. He said he advised the state, oh, well, you know, I saw Mr. Williams as this was going on at my extra job. And of course, I inquired, what are you speaking of? And then that's when he proceeded to go into further detail about it. So this wasn't anything that was in any.
So Mr. Quinn found out during, Jesus fucking Christ.
Type of reports or anything like that. And as soon as Detective Quinn gave the state that information, we immediately provided it so that.
Patty asks, is it normal for the prosecutor to always get the last word when they are arguing motions? Because I always thought the defense gets the last word. Am I wrong? You're not wrong. If the defense files a motion, they argue, the state replies, defense should have the final word. Not in this court, because a spineless judge allows the state to, if they kind of sense that the judge will rule against them, they will immediately stand up and nag and whine and bitch and do anything to change his mind. And he buckles. almost every time.
There could be an account. Your Honor, again, this is a summary of what he told the state. I would ask for Detective Quinn to come so the court can hear it yourself, how this interaction came up and what exactly he said to us. So once we...
If there's nothing written, nothing recorded, I don't give a flaming fuck or two shits on a straw about what Mr. Quinn has to say about it. It's too late.
So that the court can hear it itself and be comfortable in what Detective Quinn told us. And I believe what Detective Quinn would tell Mr. Steele or any of the other defense attorneys had they taken the time to interview him. In addition to this, Your Honor, we provided in the statement that this statement involves Mr. Walter Murphy and Ms. Dolly Greer. Ms. Greer is Mr. Williams' sister, so Mr. Steele had the opportunity to interview her to determine whether or not there was any validity to this. The state also, again, provided the copy of the phone log that has Dolly.
It wasn't turned over before the trial. Off you fuck.
Phone number in there. As a matter of fact, Detective Quinn titled her phone number Dolly-Young Thug Sis to corroborate that this interaction occurred. And then lastly, they had the opportunity to speak with Mr.
You can enter anything into your phone at any point in time. Yeah, exactly, Heather. How do you cross-examine when there is no record? Oh, but he has his sister's phone number. Fuck off.
Walter Murphy. The state knows, because I've had an opportunity to briefly speak with Mr. Murphy, that Mr. Murphy has met with defense counsel, specifically Mr. Steele, at least 2 times at this point. And so there was an opportunity to talk about this, whether or not these events happened. He could have spoken to Detective Quinn, Mr. Murphy, as well as Dolly Greer to determine whether or not this incident has occurred, or these series of events have occurred. So we would ask, as it relates to the disclosure, the state did what it was supposed to do. Once we learned about it, we turned it over immediately so that we were not going to surprise defense counsel during trial and bring this out. We wanted them to be aware of it, and we took the necessary steps in order for that to occur. Next, Your Honor, as it relates to state the order, that is not valid anymore. You know, what OR states is that the Mallory test is not valid. And so what the court has to look is to do a 403 analysis to determine whether or not this information is substantially prejudicial. And we would believe, Your Honor, that given, again, the current cross-examinations of witnesses in this case as it relates to Detective Quinn's interactions, Detective Quinn's investigation, the theory that Detective Quinn or detectives or police officers with the Atlanta Police Department has either destroyed evidence.
It's not a theory. Detective Velasquez admitted to it on the stand. Oh, read that part of the record back. Read that record back.
Hidden evidence, interjected themselves into this case. We believe that these encounters are important because what these encounters show is that Detective Quinn had no ill will towards Mr. Williams. Matter of fact, he did not take out arrest warrants and explain that to Mr. Williams. So much so that Mr. Williams, in turn, tried to offer him a job. And I think that is important for the jurors to hear, given this idea that Detective Quinn has, in this particular case, has in some way, shape, or form interjected himself in it and has a vendetta against Mr. Williams. This shows very clearly he does.
Fuck you. That's not a legal argument you're bringing forward. That's an emotional argument, a theory, speculation. No, this is in front of the jury. The jury is still out.
Not have a vendetta against Mr. Williams and did not have a vendetta against Mr. Williams. And matter of fact, wanted Mr. Williams to just go forth in his music career, continue to be successful, and like he literally told him, stay off Cleveland Avenue. And so, Your Honor, we would ask that you allow this testimony in. Again, if the court wants to hear specifically what Detective Quinn remembers about these encounters, he is right outside. You can hear from himself so the court can be satisfied with what the testimony will be, because it will stay within the confines of what he remembers, Your Honor. And again, for him, it's also
if he didn't remember it until recently, after the trial started, and there is no written record, then off you fuck. That should be a motion of off you fuck.
Years ago, and he's basing those interactions off of his memory as well.
Based upon your interview with the state's interview with Detective Quinn, is he going to testify within the confines of the court's exhibit that's been submitted for the purposes of this particular hearing?
Yes, but I don't want to, it says within the confines, but if he says one additional fact, I don't want to be, withdrawn, because if there might be an additional fact, this was really a summary of that encounter. But that was a summary as he had.
So he
explained
can
it to
make
the state. I
shit
don't
up
think
on the
anything would veer
spot.
too far off of these encounters. But again, I'll feel more comfortable for the court to hear from him, because again, these were the encounters that he relayed to us. I don't think there's anything far out of the bounds of here, but again, this was a summary of what he told us.
All right. Okay. Detective Quinn's on side?
Yeah.
All right, can we bring him in, please?
Oh, for fuck's sake.
Could have a seat in the witness that you're still on the road, sir.
Yes, sir.
If you would be so kind to kind of reflect back to 2013, when I understand from counsels that you had an extra job working at Neiman Marcus.
Yes, sir.
And that you had 4 interactions with Mr. Williams,
Yes.
reportedly, and that you summarized that in a written statement, gave that to the defense, and this is consistent with the preparation that around this.
So you made shit up, you wrote it down, said, oh, I promise it's true. And now they're going to use that in trial. For fuck's sake.
December of 2023 that you had with the representatives from the state of Georgia, is that correct?
Yes, Your Honor.
Okay. If you could tell the court a little bit about those particular 4 interactions, as much as you can recall, consistent with what you told them.
Yes, sir.
Them being the state, okay?
Yes. So while in the throes of the investigation into what happened down at 126 Cleveland Avenue and 2745 O'Hapeville, I worked this extra job at Neiman Marcus at that time, I guess, since 2004. So I'm there every Friday. I had never seen Jeffrey Williams, to my knowledge, even come in the store. But a week, maybe 2 into my investigation, Jeffrey Williams comes in to Neiman Marcus, and I'm sitting on a stool. I've got on my City of Atlanta police uniform. I'm not a detective, in my detective attire. And I waved him over. I said, come here, let me holler at you.
So you were a mall cop and you used your actual police uniform on your other job? I don't think that's legal. To use your cop uniform while performing another job, a job that is not you being a cop. And even if it did happen, I don't fucking care.
Right quick. I told him directly right then and there, this joker named Bean, he's put you in this car that went off that cliff over there on Old Hayville, right into 126 Cleveland.
Why the flaming would you in Neiman Marcus sitting on a stool working tell Mr. Williams that Mr. Bean gave him up? Why would you out an informant to a person you believe is a dangerous gangster? Why? This is so full of shit. This is so full of shit. I've seen piles of manure smaller than the piece of shit this officer is. As GD says, judge wouldn't allow the defense to bring up prior statements made by Bean that is referenced in 2 recorded interviews. Yet judge allows this stretch of imagination in as evidence. AA's heathens. Dressing up in an official cop uniform while being in a mall cop is illegal and considered impersonation. Yeah. While on his other job as a mall cop or at Neiman Marcus store checking for shoplifters as a mall cop, he was, Jesus Christ.
I said, I'm telling you that because you're going to get the discovery anyway from somebody else in the car. You know what I mean? You're going to learn this happen. I'm telling you, I'm giving you 100%. this guy's putting you in the car. But what I did tell him,
why the fuck would you give out information in the middle of a store about a snitch you have to a suspect? Jesus Christ.
was the same guy, Bean, was identifying which gun he had during this commission of this robbery that turned into a police shooting. And I said, I'm not going to lock you up based on what Bean said alone. If there's DNA, this touch DNA was really moving in 2013. If touch DNA comes back with male profiles on, I just said to him, boom. Are you going to make me come get you with a warrant, or will you give me a voluntary sample to eliminate you from this case? And I assured, I said, I'm not going to lock you up with what Bean says alone. I need something else. That's how I get down. So Mr. Williams was like, I don't even know what you're talking about. He was adamant. He seemed very—
So while performing as a mall cop, you were trying to solicit DNA from a person. What the actual fuck? Jiggy says, I think he's saying Neiman Marcus hired a police detail. Okay. That might be it. But Jesus Christ, this is so bad.
very nervous because, you know, I'm a uniform officer coming up with this stuff in him, right? In some store he's coming to in his free time. A few weeks go by, maybe 3, because I got the DNA fast tracked through the GBI. I learned from the analysts.
I thought there wasn't any DNA in this.
There were too many male contributors to the gun that Bean identified Jeffrey Williams being in possession of. They wouldn't be able to put a usable sample up into codes.
Yeah, that's true.
So a few weeks later, Mr. Williams comes back in the store again. I don't know what day, but it was weeks after the first encounter. I said, yo, come here. Let me holler at you.
And none of this you put down via pen and paper. Nothing.
I said, guess what? I can't use that gun against you as corroborative evidence or evidence against you based off what Bean said. So I tell you what, I'm done with it. I did some research on you independently because I didn't know you were about to blow up. I said, and excuse my language, I said, go make $1 million, stay the fuck off, please. That's what I said to him. Maybe a month or 2 goes by after that. I'm at Neiman Marcus again. Now Mr. Williams comes in the store with a couple of people, a small, I guess you would call entourage, just maybe some associates. But in particular, he introduces me to his sister, Dolly. Didn't know this sister at all. She gives me her phone number. They asked me, would I be their road security collectively between Mr. Williams and his sister? I was like, that's not what I do. This has nothing to do with this case. I did take her number because Dolly gave me her number.
So you were soliciting getting a job, which you didn't get. That is what I'm reading into this.
Put it in my city issue phone, Dolly, Young Thug sister, or something to that degree. And that was the end of it. The fourth encounter may have been months on down the road, might have been 6 to 8 weeks. Mr. Williams comes in. We don't have any verbal contact in the fourth encounter. My stool that I sit on is right at the downstairs escalator going in menswear. Mr. Williams is with DK, real name Walter Murphy. And from about 25 feet away from me, he's pointing to Walter Murphy's like right pocket to his pants. And there's a long stack of money in Walter Murphy's pockets as they're going down the escalator. He points at it and he doesn't say anything to me. He just makes reference to it, make sure I see it. I don't know what that meant, you know, but that was that. So those were the encounters.
Okay. All right. Either counsel have any questions based upon the court's inquiry?
I don't have additional questions.
All right, Mr. Steele, you have any questions based on the court's inquiry?
No, sir.
Okay. Detective, thank you, sir. If you could step back out. Okay. Yeah, sure.
I don't think you should have questions for Mr. Quinn at this point.
Today, sir.
Mr. Steele.
Good to see you, as always.
Always a pleasure.
Can I just ask you a couple questions?
Yes, sir.
Did you in any way record, memorialize, write down, any type of note in any form? I'm not be expansive to remember any one of these 1, 2, 3, or 4 that you took.
I did not at the time, no.
Okay. And when dealing with Mr. Williams, it seems to me, there's no custodial situation. This is just come over here. If he didn't want to come over there, he walks away. Is that
Correct.
okay? All right. That's I just want to make sure.
Okay, all right. Detective, I get you to step outside. We'll be
Yes,
with
sir.
you shortly, okay?
Yes, sir.
Thank you, sir. Okay, any further argument?
No, Your Honor, like I said, I think that pretty much was in the paper, but again, for the reasons stated, sorry. For the reasons, no additional further argument.
All right, Mr. Steele, anything else, sir?
I'm not going to repeat, Your Honor. The only thing I do want to add new is Watley, which is WHATLEY versus State, which the state cited 326 Georgia Appeal 81/2014. Watley is not part of the prosecution team. It is a wife statement or a woman statement or a relative statement. Now I'm not targeting it perfectly in my mind, but this detective is part of the prosecution team for purposes of these overt acts, meaning that it's imputed to the state under Kyles, which is KYLES versus Whitley, WHITLEY. That's the United States Supreme Court opinion from 1995. I could get you the site. It's cited often.
If you could let me know the site.
May I just step back 1 second?
Okay.
I get right now.
Taylor King, we are
514 US.
we are a bunch of hours behind.
514 US.
I did a recap of Friday, and then I'm doing. I will try to get as far as I can on today, but I need my sleep because I have a 4:30 a.m. start tomorrow, and I'm transmitting this from Sweden. But yes, I am live. I'm live. I am live. But we are a few hours behind on the actual trial.
Yes, 419.
419. Thank you, Mr. Matthews.
May I just say one sentence and then I'll sit down and let you read? Kyles versus Watley is a Brady case. The government was saying, hey, I didn't know about it, so how could the prosecutors turn over this Brady or Giglio evidence? Giglio is Giglio. And the U.S. Supreme Court said that's not the standard. If a person's part of the prosecution team, it's imputed to the prosecution, just like now. The state can't just hide behind, I don't mean hide in a mean way, but they can't just say, well, we didn't know about it, but a member of our team knew about it. But since we didn't know about it, then the code section under discovery.
Yeah, I think that is proper. If the law enforcement here is part of the prosecution's team, him remembering it this late, too bad. Off you fuck.
That I cited to Honorable Court do not apply. I don't believe that that's true. So that's why I just tell the court.
Please, Judge, make a good ruling. Please make a good ruling. Speeding ahead a bit.
Next court exhibit in order, the statements that were turned over based upon the state's interview with Detective Quinn on or about sometime December 29th of 2023, which chronicled 4 interactions with purportedly with Mr. Williams.
Come on, Judge.
His sister Dolly, and then Mr. Walter Murphy. the court's had an opportunity to take a look at or consider for the purposes of this particular motion, OCGA 17-16-4A1 and OCGA 17-16-7. 17-16-4A, basically indicates that statements should have been or to be disclosed at least 10 days before trial. It has some other disjunctives or soon thereafter. And then 17-16-7 basically indicates or gives the court directions as to statements that are in the possession of other entities that are imputed upon the state. The courts also had an opportunity to consider State versus Orr 305 Georgia 729. As well as Whitley at 326 Georgia Appeals 81. The courts also had an opportunity to take a look at OCGA 17-16-6, which is court orders with respect to failure of the state or the defendant to comply. So, and this pertains to the discovery statute. Anytime during the course of the proceedings brought to the attention of the court defendant or the state has failed to comply with the requirements of the article, the court may permit the defendant
Come on, Judge, make a good ruling.
to inspect, interview the witness, grant a continuance, or if there's a showing of prejudice and bad faith, prohibit the defendant from introducing the evidence, not disclose or presenting a witness, not disclose, or I can enter any other such orders deemed appropriate in the circumstances. So in this particular circumstance, it is of the court's opinion that the state didn't act in bad faith. This is part of
for
prep that they
fuck's
did
sake.
for this particular trial.
This has nothing to do with bad faith or good faith. You can't just let shit in just because the prosecutions are imbeciles. Just because the witness is a fucking moron. You, Jesus fucking Christ. You absolute fucktwat.
The reason the court asked how long that if Detective Quinn had been interviewed
has nothing to do with it
in regards to these particular
twat.
4 interactions, because that's what the court would allow the parties to do. Having heard Detective Quinn's interactions and giving the Mr. Williams counsel as well as the state an opportunity to examine him, and also if the statements were turned over to Mr. Williams and other members of the defense team around December 29th of 2023.
You absolute moron.
March the 25th of 2024.
Get away from that stand, Your Honor.
Parties have had some 3 months or thereabouts to.
It had. So, just because we are 3 months in, you can move in whatever you want, as long as the lying, cheating, corrupt cop writes a little affidavit.
To talk with Detective Quinn about any of these 4 statements. So for those reasons, the court will authorize, with of course, with the necessary foundation to be laid for Detective Quinn to testify about his interactions with Mr. Williams at the Neiman Marcus store that he's that are fairly contained within the next court's exhibit and order, as well as his proffer and testimony to the court. Now, Mr. Steele,
what happened here? I mean, technically, the state have had access to this via Detective Quinn for over 10 years and chose to not disclose it until after the trial began. It should be thrown out as first. But no, this judge will let anything in. Anything. You could have a 70-year-old Polish whore coming in from the street saying, "Oh, I heard this back in the day. Let me sign and swear an oath." And this fucking retard will get it in.
Or seems to, or you know, there wasn't. What was the other test in Georgia? I remember. Trying to remember. Mallory test. Is the state going to comment on Mr. Williams' silence?
No, the state intends. I don't think Mr. Williams was silent at all. He was fine. Based on what Detective Quinn provided, Mr. Williams' response was, "I wasn't a part of that. I'm a rapper." And so.
Yeah. So sorry, Patty. I don't know what to say. I don't know what to say. This is the state of the American justice system. Yeah, we will continue this tomorrow. I have very many words, and I need to cool down a bit. Because I'm demonetized, that I am already, but I don't want to be yeeted because I have stronger words than I usually have. Sorry, Gosler, it's Fulton County, Georgia justice system. Okay. We will continue tomorrow. Gigi, it's not Yodi Day tomorrow. Me and Dave, our schedules are just too full. So we are going Yodi Day on Saturdays alone. But I can't do this trial, and I will return tomorrow. We will watch the rest of day 48. And all right. Let's finish with what I always say. Hug your family. Unless your family's shit, then fuck them and give your love to the people who deserve it. Okay, I see you all back here tomorrow. Bye-bye.